Hello, my name is Robert Goodwin, and welcome to Law on the Line. I'd like to invite my guest for this program, Frank E. Tenor, who is a certified family lawyer in East Brunswick, New Jersey. And Frank has been practicing since 1992, which, 32 years?
32 years, yep.
Okay, good. And as I said, Frank is certified as a matrimonial attorney since 2009, and he focuses his practice on all areas of family law. Welcome aboard.
Thank you for having me. I appreciate it.
Very well. So today we're going to talk about a topic that has been of significant note in the area of family law since a recent decision in 2023 by our New Jersey Supreme Court. And one of the things that I noted in my preparation is that the alimony statute, the new alimony or revised alimony statute, it goes back to 2014.
It's not so new anymore.
Not so new, right? It's almost a decade old. And the Supreme Court decision is from 2023, I think August, I believe, of 2023. So my question I want to start off is, Frank, if we had a statute in 2014 that defined our topic, cohabitation, why did it take 9 years for our New Jersey Supreme Court to set forth the procedures for a party who is paying alimony to know how to proceed and to move forward with the case in which cohabitation is the central issue? So what goes on, Frank?
Well, as you know, these cases, nothing in the law goes too quickly. So they have to wind their way up from the trial court to the appellate division and ultimately to the Supreme Court.
But what was wrong with the statute to begin with? That's what bothers me a little bit. If we spend all this time on legislation, and we have the statute here, Frank, and you provided the statute, and why 9 years to get a straight reading of a statute, which to me is pretty simple?
So case law or statutory law doesn't come with a handbook. It says this is the statute. In this particular case, the statute talks about...
Here, make it easy for yourself.
Thank you. The factors to look to: intertwined finances, sharing joint responsibility, recognition of the relationship within social and family circles, living together, frequency of contact, duration of relationships, indicia, I love that word, of a mutually supportive, intimate, personal relationship, sharing household chores, recipient has received a promise of support, and all the relevant evidence. Seems straightforward, right?
Right, it does.
However, we have judges.
Right.
And these judges bring their personal beliefs and backgrounds, and not everyone looks at these terms the same way.
And we're talking about a situation where a person was married, divorced, they're paying alimony to the other spouse, and we learn that the other spouse, or they learn that the other spouse, or believe they learned that the other spouse is living with someone.
Right.
Okay. I just wanted to set the table so everybody knows where
You're
we're
right.
going.
I should back up by saying in New Jersey, we have alimony. And
Correct.
Alimony is intended to maintain the lesser supported spouse at close to the standard of living enjoyed during the marriage. That's the ideal, at least. And there are a number of reasons where that may stop or be changed. Change circumstances. That's the magic word. And one of those changed circumstances is cohabitation. The theory being, if I am paying support to my ex-wife and she starts living with someone else or cohabiting with somebody else, and that person is filling my role, is now helping to support her, why should I have to support her? And originally our courts said, yeah, that's absolutely a correct position. You should not have to support someone who's living with someone else. That was from a case called Conzelman going all the way back to 1999.
So that's 26 years ago. And then we had a statute that was enacted in 2014 that sort of tried to incorporate
Right.
councilmen.
Right.
So what, but, okay, so when we have this statute, so what has been the problem and why did we have to have Cardelli?
So I mentioned the judge's interpretations. There was one appellate court, and I know you're aware, but the reminder is we have a trial court. People don't like the decision. They go to the appellate court. The appellate court then makes a decision. If the powers that be think it's an important enough decision, they publish it.
Correct.
And say this is now going to be the law in the state of New Jersey. If the appellate division is appealed, it goes to the Supreme Court. Supreme Court is the ultimate arbiter, and they literally lay down the law. So after the statute was enacted, different judges interpreted it in different ways. And
At the trial level or at the appellate level?
at the trial level, initially it's the trial level.
Correct.
That's where the rubber immediately meets the road.
Okay.
And then, so that the trial court judge said, well, these are the factors. I'm looking at 7 factors that the legislature has said that I should look to, and I'm going to want each and every one of these factors met before I agree to have a hearing.
So how does, starting from the beginning, a litigant says, I don't want to be paying, I shouldn't be paying alimony any longer, and they're divorced, and there is an agreement that they've entered into, let's assume at the time of the divorce, they're ordered to pay a certain amount of alimony, either consensually or by court order. How do they approach the court to initially address that topic?
I'll tell you how I get confronted. A client calls me, I want to meet with you. My wife, and I'm saying my wife, sometimes it's my husband, the payee, person receiving the alimony, I believe is cohabiting.
Okay.
And I want to prove it because I want to stop, or I want you, lawyer, to stop me having to pay that alimony. So I look to the statute, I look to the case law, I say, all right, we have to prove these factors. And the most effective way, although it is the most
yes. Costly,
is to go hire a private detective. And to hire a private detective to record, well, they slept overnight together, they went on vacation together, he's over the house making dinner for her, they went to a wedding together, so making the world know that they were a couple, if you will. You have to start recording those things. Ideally, best case, and if the clients can afford it, I go tell them hire a private detective. If not, then we have to resort to alternate means. Adult children sometimes will say, you'd be surprised how often adult children are annoyed at the one parent who's cohabiting when they know that the other parent is paying
for it.
Yeah.
Sure.
So I've had a number of cases where adult children will report.
So it sounds pretty uncomplicated right up to this point. My former wife or mom or dad is living with someone. One of the parties is paying alimony to the other. You get these facts, and why? And it seems pretty obvious. You're going to prove cohabitation. What happened with the courts after the enactment of the statute? Not meaning what happened with the courts, but how did the courts look at it? How did they interpret, or did they require all the factors, some of the factors? How did you get to that level after the motion?
So we had 2 diametrically opposed lower level cases. One was called Temple, and the other one is going to escape me right now.
Okay, don't worry.
But basically, the one judge said, I want every factor. He looked at it like a checklist. Mm-hmm. There are 7 things. I want everyone checked. If you got 6 out of 7, you're out of luck. The other judge said, well, I believe that if you have enough factors that a reasonable fact finder could determine or would be able to be determined, then I'm going to have a hearing. And I think it's important for me to note, we don't just stop alimony based on certifications. Usually. I mean, it'd have to be really extreme proofs where a judge said, I don't even need a hearing. Usually what happens is the judge says, all right, I think we have enough evidence called a prima facie showing of cohabitation that we're going to have a hearing. And before the hearing, I'm going to let the lawyers exchange what's called discovery. You're going to be able to ask to see the other party's bank accounts. You're going to be able to look at their personal items that you would not be able to, particularly on the regard to the finances. The intertwining of finances is almost never something that someone can do without a court order.
So how did, if you know, I mean, if the statute which we read, or if we, I don't know if we read it actually on the record, so to speak, or on the show, and I think we did, the intertwined finances, shared responsibility, where does it say in the statute that you had to show all of these factors?
Where does it say in the statute that you didn't? That was
True.
the problem.
That was the problem, okay.
Right, so one judge interpreted it very strictly. I want each and every one of them. The other judge took a more reasonable approach. This case, Cardali, worked its way up, and the Cardali judge basically said, I want every factor. The appellate division said, well, the way we read the statute says you have to have these factors. They affirmed.
Meaning, what does affirm mean, Dave?
That means the lower court got it right.
Okay.
And
so
we're
in
going
the lower court decision, Cardali, that all 7 factors had to be established, at least on a prima facie level. And if one was not, for example, intertwined finances, you were out of luck.
Right.
Okay.
Appellate division, Supreme Court said, we want to hear this case.
Okay.
Because we want to clarify for all the lawyers out there, and by extension, all the litigants, the clients, the people who have to pay alimony or are receiving alimony, that this is what the law is. You don't have to have every factor. And specifically, I want to kind of read what the court said. Justice Patterson basically said that the movement's burden at the preliminary state is not an onerous one. A high bar is not intended. It's merely a threshold showing so that the party's privacy is not baselessly invaded. Because the court, and all the courts really, have this sort of weighing test. Are we going to invade this person's privacy, the receiver of the alimony, based on flimsy proofs, or versus, hey, is there a valid case to perhaps terminate this alimony based upon cohabitation? So the court struck a balance and said once a prima facie case has been made, discovery can be ordered. And it should be discrete discovery, meaning we're not going to let you have every piece of discovery. You're not going to be able to look at everything the person has. You're going to have to show a judge at the trial court level that, judge, this is what I'm asking for, and these are the reasons. Now, and when I say that you have to show a judge will order discovery. A lawyer sends out, well, these are the things I want.
Those are interrogatories.
Interrogatories, questions under oath or notice to produce, documents from the other party. And the other lawyer may object and say, wait a second, Judge, this is too onerous. It's not fair. It's not relevant to the issue of cohabitation. And then a judge ultimately will make the decision of, okay, I'm going to give you some of these things, but not all of them, as an example.
Is any one factor more important than another? For example, if you were able to show parties are living together, they go to family events together, you see them food shopping together perhaps, or engaging in other activities that a couple who are married would engage in. The fact that at that point in time you are not able to show intertwined finances, is that something that would keep you from moving forward?
It would have prior to Cardali, but now under Cardali, the courts have indicated that if you have some of the factors that would cause, I want to read it again, to cause you to have a prima facie case, indicia of a sufficient number of cohabitation factors will entitle you to limited discovery. That's the big rub. Is it a dating relationship or is it cohabitation? People can move on with their lives. An ex-wife or ex-husband is not bound to their spouse forever that they can't have a relationship. They just can't cohabit. So,
and that would be a relationship that has all the indicia or the attributes of marriage.
correct.
So,
Or at least enough that we can have a hearing.
okay, so if we're at that point where, well, let me rephrase that. Since Cardali, which is not that old, I mean, it's been decided last year,
Right.
in the fall of 2023. Do you know, and have there been cases now testing that case in terms of a litigant being able to establish a prima facie case?
Well, Cardali pretty much has made it much clearer. Now, we have the family bar is a very active bar at the state level, and there are a number of task force. Was it a panel discussion which you attended?
Right, that is correct.
With some task force members that are working to clarify the court rules and language. But I think Cardali has made it pretty clear that you gotta, if you have enough of these factors to convince the judge to go forward, it doesn't have to be all the factors, but enough. And one of the factors that I would, that I always use is social media. When I have a client come in and tell me, I think my wife is cohabiting, the first thing I say is, well, let me look at my ex-wife is cohabiting. Let me look at your Facebook page, because you'd be surprised how people are so enamored or in love with their new relationship that they want to post pictures and say, we're in Cancun together, another great wedding. I love him more than anything. And I sit there and print them all out and say, okay, that's Exhibit A for my motion.
But if you have Exhibit A and you have, if going back to the statute, and we have other exhibits
Sure.
which establish, sharing of responsibilities for living expenses. In your particular case, going on a vacation together, relationships within social and family circles. I, as the recipient or of the alimony, oh yeah, no issue about that. But we are very specific about it's my money. I use my money for vacations. I use my money for restaurants. Oh yeah, we live in a house together, but it's my money that pays the mortgage, or half of my money goes to the mortgage and half of his money goes to the mortgage or rent or whatever. How do you juggle that, Frank?
Right, it's the Fannie Willis defense.
The Fannie Willis defense.
Right.
Okay.
Like, oh no, I paid for my stuff, he paid for his.
For our audience, who's Fannie Willis?
The prosecutor in Georgia.
Aha.
Who
Yes.
became
Okay. That is correct.
Involved with an individual allegedly, and I guess the Trump. Some of the defendants on the Trump side attempted to have her disqualified
Right.
for having a conflict of interest. To answer your question, you have to. That's once you show, Judge, they've been on vacations. I have, in the 3 weeks of surveillance, I have 17 overnights. He goes over and he has a key to her house. She comes over to his house and cooks dinner for him and sleeps over. The children know each other. we have pictures of holidays where they're all together, family, both the cohabitants and their kids.
The cohabitant drives my mother to the doctor or my
Right.
children to the doctor, those kinds of things. Go ahead.
So now a court will usually, based on that, will say, all right, well, look, the fact that you pay for everything, that's a defense that we're going to have at a plenary hearing. But for now, I'm going to order a plenary hearing, and let's explore these issues in greater detail.
Good. Now, you mentioned before discovery. And I know that you were a part of the panel in, where there's people, lawyers in Trenton trying to get some changes in the rules. What's the status of that with regard to our court rules and with regard to interrogatories or discovery?
Well, they're talking about having uniform interrogatories. I would love it for all cases, but particularly with regard to cohabitation cases. For the very reason we touched upon earlier, discovery should be is intended to get to the truth and get facts that are important to prove a case. Sometimes interrogatories, notice to produce, can be abused, and a party can send 200 questions they want you to answer under oath, and you have to sit down, usually with your lawyer, or at least the lawyer is going to review it at some point, to answer these things that are not germane to the issues involved anyway. And it's a big enough issue that the bar is looking to address it and change the court rules so that we can limit discovery so that it's really focused on the issue. It's not something that lawyers use to abuse the other party. It's used to get to the truth.
And right, and it's important that there be some limitation because otherwise you make these cases very, very expensive. At a plenary hearing, and people hear that word plenary hearing. What does that really mean, Frank?
I'll tell you the truth. I don't know the difference between a trial and a plenary hearing.
Okay, I'm all right. That's why I asked the question.
It's a trial. It's basically a trial. I guess a plenary hearing is just a different. It is on a discrete issue. I'm guessing that or thinking that's the reason. But it's a trial.
And family law, there are no juries. I mean, I just want to set the table for our general audience. So you're really before a judge, who usually is assigned to the family division.
Right.
Okay. So what instructions would you give our audience members who may find themselves, perhaps without counsel, at the level of, you have the right now to have a plenary hearing, and now I'm in panic, and that's going to be in 2 months, and you have a right to ask questions of the other side, relative to the issues that are in the cohabitation statute. What would you suggest to give them guidance as to how to proceed?
Aside from
getting a lawyer.
Number one, getting a lawyer.
Which I recommend. This is complicated stuff.
Yeah. I always joke, like, people say, well, do you think I need a lawyer for this? I'm like, well, you don't need, you can remove your own tooth, but most people would rather use a dentist to do it. So if you were I'll give you an example of what I would do. I have my discovery. Now I'm going to sort of in my mind say, well, how do I want to tell this story to the judge? Because that's really what a trial is, telling the judge the story and showing why these are the strengths of my case, these are the weaknesses. Absolutely the worst thing a litigant can do, particularly a pro se, which means someone who's not represented by an attorney, is just saying, well, I'll just tell the judge my story and the truth will out. Right. Yeah. Unfortunately, that's not the way it works. We have rules. So the first thing I would recommend is at the very least, read up a little bit on the rules. Secondly, think about how you want to present this case. Okay, I want to prove that my wife is having a relationship. I'm going to testify, judge, these are the factors that I have and that I've found that you should look to. Facebook pages, look, they're at parties together, they're sleeping together 6 days of the week, according to my son, who's willing to give a certification or testify in this case. I'll testify at trial.
That's a good point. Would the son have to come in your scenario, to court to testify, or will a court look at a certification?
Absolutely has to testify if you want the judge to hear it.
Okay, go ahead.
You know, in the initial, before the plenary hearing for a prima facie case, then you can send a certification. But a court will not listen to an out-of-court statement that's being offered to prove the truth of the matter is asserted. So
otherwise, it's hearsay. Right.
Absolutely.
Right. Okay.
So you would have to bring the son in. Now, things get sticky. Is your son 32 years old? The court's going to have no objection to that. Let him testify. Your son is 14 years old. That's going to make most judges a little queasy. They don't want to have children testifying against their parents unless it's absolutely necessary. And by that, I'm thinking like division of child protection cases.
Abuse or something along
not
those lines.
To stop alimony. So like every answer in family law, it depends.
It depends. But so what, these hearings take place in a day, just give us a sense of the timing of it and
right
after the prima facie case has been established.
All right, so judge sets it down for a hearing, and many people think, oh, great, my hearing is Tuesday the 14th. I'm going to show up. I'll testify all day, or maybe half the day, and then the judge will make a ruling right then and there. That's how it works on TV. That's not how it works in the real world. The real world, you're going to show up in court. Judge is going to say, all right, we're going to start the trial at 9. Oh, wait, I got an emergency. An order to show cause has come in.
Frank, I have 1 minute, so go ahead. Yes, order to show cause comes in, and?
And as a result, you're only getting a half a day of testimony. Come back again in 2 weeks. Then come back again in 4 weeks. It's tough to be in the court system. That's why these cases often settle.
And you're also subject to cross-examination.
Yes, absolutely.
And people forget that oftentimes they think they can tell their story and it's not interrupted by cross-examination.
Right.
Any tips, any final tips, Frank, or as you see the future with regard to legislation in terms of interrogatories, changes in the court rules, or?
Well, I'm not sure how. I think the court system in general doesn't like these cohabitation cases because it is an invasion of privacy. I'm almost wondering if we're going to move to a alimony statute where cohabitation perhaps doesn't eliminate alimony but reduces it, which the court can do to avoid whereas a person might say, all right, I'm willing to reduce my alimony, but I'm not willing to tell my husband or ex-husband that I have a cohabitant, but I'm not willing to just end it altogether.
Because the statute does say alimony may be suspended or terminated. It doesn't say anything about modified. Is that, in fact, still the law?
Right now, no. That's why I think the law is going. I think there's going to be a call for some modification.
But a court can't do that right now. Is that correct?
No.
So it's either suspended, which I guess means it could be renewed at some point, or terminated. So it's all or nothing, almost all or nothing proposition.
Right.
Okay. Well, I know that I've gotten a signal, and we've met our. The time is up, Frank, and it was a pleasure having you.
It was a pleasure. I wish I could.
We could talk about this much longer,
right.
And I hope that the audience really, gets a grasp of the subject, and also that something that could be only 100 words, 120 words long in a statute has created a lot of litigation and a lot of confusion over the last few years.
120 words, but a lawyer can make it into a book.
A book. A novel.
Yeah.
All right. Thank you so much.
Thank you very much.